I have 2 points to make, one of which does affect trade and commerce, and the other of which, and I'm perhaps trespassing on the goodwill of the International Trade Committee, is much more profound because it affects civil liberties. It says here in the document here, it says, draws attention to the problem linked to the legal uncertainty of commercial exchanges and to the issue of which jurisdiction is competent for the settlement of a given dispute. Now, if not a majority, certainly a plurality of international trade contracts say that in the event of a dispute, the dispute shall be settled with reference to British law. Now, this activity is very beneficial to not only, this advantage to this reference to British law in international trade contracts is first and foremost of huge benefit to the contracting parties. Otherwise, they would not enter into it. And I have to say that I find it extremely worrying that the issue of which jurisdiction is competent for the settlement of a given dispute, because I can see that what seems to be happening here is that the right of contractual parties in a trade negotiation or trade agreement to choose which jurisdiction they want to go under is possibly going to be taken away. So I would flag now our strongest possible opposition to this, and I would very much hope that other political groups would join us in laying down the situation that contracting parties must have the ability to decide which jurisdiction they want to go under. Now, I'm now going to trespass perhaps a little bit on the goodwill of the committee because it's not entirely under the word of trade, but it is none. But we're all politicians, we're all citizens of the European Union, and so on. We're citizens of our own countries, which are members of the European Union, I should say. It says here the process of harmonisation of legislation across Europe can be very beneficial. It also says in the communications. It also says in the action plan implementing the Stockholm programme, in the preamble it says here, women and men in Europe rightly expect to live in a peaceful and prosperous union, confident that their rights are fully respected and their security provided. Very true. Now, what has unfortunately happened is that in this thrust for harmonisation, which was, if I may say so, extremely ill thought out, we have the European arrest warrant. Now, the consequence of that has been wholly damaging to the interests of UK citizens. And 2 of my constituents were banged up in jail in Hungary. Sorry, Mr. Stashny is not actually here. Were banged up in jail in Hungary for over 100 days on waiting to be brought to trial. And they could have been imprisoned for a period of up to 3 years, still waiting to be brought to trial. Now, I personally went there, was very well treated by the Hungarian authorities, and they were actually let out on remand, although the charges have not been dropped. And I'd simply make the point to the politicians here that not all legal systems within the individual member states of the European Union are the same. And some legal systems in some member states have a much higher respect for the rights of the individual. For instance, habeas corpus, no imprisonment without trial, trial by jury, and so on. And one of those places is the United Kingdom. And the push for harmonisation, in fact, in the context of the United Kingdom, as well as doubtless other countries, and I defer to my colleagues here, will have the effect of reducing the rights to which people are entitled to, reducing their security, reducing their justice, and placing their freedom at risk. And that is why I urge members of other particular groups, particularly members of the left and the liberals, who in other contexts are very protective of civil liberties, to bear in mind that harmonisation, when it's ill thought out, which it has been under the Stockholm programme, actually threatens the right of the individual. Thank you. Could the representative of the Commission make some attempt to respond to the 2 points that I made? If he's unable to do so, perhaps I could write to him. I could get a written response. But you've made absolutely no attempt at all. These are two very, very serious points which you've just ignored.
Will the Commission answer to the concrete questions that were put forward?
To be very honest, I didn't understand the relevance of your question on the made-in regulation. I couldn't make the connection. It was a very political question on harmonisation, which is, I don't think was for politicians.
I also asked a question about the right of contractual parties in trade agreements to be able to choose which jurisdiction that they choose to have agreements their agreements reconciled under in the event of dispute, which is a very specific trade question. I spent about 90 seconds talking about that.
Yes, but there's nothing in this regulation touching upon international contracts or disputes or anything.
No, I highlighted the quote, the issue of which jurisdiction is competent for the settlement of a given dispute. I sought some clarification on that, please. Okay, but can we? But I must say so. On the point of order, though. What?
I think we have a quid pro quo here. I think Mr. Armand's referring to another text relating to the Stockholm programme, but that is not germane to the regulation that we are dealing with this morning. Now, the point he's raised is undoubtedly very important, so I would suggest that he send a written question to the Commission on that particular point regarding the Stockholm programme, but I don't really see this as part of this morning's debate.